Shelley? Okay. Well, let me call the meeting of the Alachua County Charter Review Commission to order. Today is June 23rd, 2010, and we appreciate everyone being here. I want to welcome you to what we think and hope will be the final meeting of the 2010 Charter Review Commission. This process began with the appointment of the members of this commission last summer, and we've worked diligently over the last 10 months. And we appreciate the hundreds of citizens that have participated in this process in one way or another. We've had some outstanding presentations and appreciate so much all the citizens who took time from their busy schedules to actually speak to and write or to make a presentation before this commission. Your participation has been unprecedented, and we are on the commission all thank each of you for your work here. We especially want to thank those members and citizens who took time to submit proposals for our consideration. We spent many hours studying on our own and together and thinking about the proposals. In total, we received 63 proposals. In some cases, we received several derivations of the same idea, and in the final analysis, only about 25% of the ideas have made it through our filtering process. Regardless, please know that we looked at every idea, and I'm sure that each of us gave each idea thoughtful consideration. We've previously thanked the county staff, but I also want to thank Sarah Blakely, our independent counsel. She's provided us with very thoughtful and well-researched information. She's responded with professionalism and has tried to pull together all of our instructions and keep us moving forward in a meaningful way. So thank you, Sarah. Lastly, I want to recognize the extra efforts of all the members of this commission. Unlike some previous charter review commissions, not one member resigned. Almost every member attended every meeting, and the esprit de corps and the collaboration for a commission made up of 15 people representing the diversity of our county has been remarkable. We look forward to sending forward our report, happy in the knowledge that the final decision on every proposal rests with the voters in November, as provided in the charter and in the true spirit of home rule. With that, I'm happy to recognize, before we get started, any member that would like to make comments here, and then we'll move on the agenda. Yes, sir, Mr. Brinkman.
Mr. Chair, it came up at the last meeting, and I just want to reiterate at the beginning of this meeting so that everybody will understand about the way a public meeting in Florida is supposed to be conducted. I'm referring to the idea that we do not applaud or jeer anybody's remarks, so that everybody is made to feel comfortable expressing their point of view. I just wanted to state that at the outset. Thank you.
We appreciate that, Mr. Brinkman. We appreciate everyone recognizing that we're happy to have everyone here, regardless of whatever you'd like to say to us whenever that time comes. And so we're anxious to hear from everyone. Any other comments here before we get started?
Really,
Mr. Martin.
Thank you, Mr. Chairman. The one person and I loved your opening remarks, but there was one person that you did leave out that we should thank, and that is you, sir. Oh. I think that you have done a remarkable job chairing this meeting.
Thank you very much, John. I appreciate that. It's been a team effort, believe me. I do want, Mary, could you stick this on our board real quick if Shelley can put this up real fast. It's always nice. I know we've got a lot of folks that participate in our community, but I saw this and I think it was in the. Can we get that on the? Okay. I should have warned her. There we go. Anyway, Professor Little, we just wanted to recognize you. It's great when students remember their professor, and out at the university, some of his former students set up a special fund, it's called the Pro Bono Support Fund, which offsets out-of-pocket expenses incurred by students who volunteer for pro bono work. And he was recognized for his many years of doing a lot of pro bono work. And we just wanted to recognize you and really see that picture up and see it blown up like that mainly. But anyway, we do recognize your efforts out there, and I think that's a real nice honor. Okay. With that, we're ready to move on to, if we could get a motion to approve the minutes of June 9th, 2010.
Second.
I'm sorry, I missed who said that. Mr. Little? Okay, thank you so much. Moved and seconded. I just had a couple of little Scribner's area that, with your permission, I'll bring those to Mary's attention tomorrow. Just a word misspelled or something in there. But other than that, any other additions or corrections need to be noted in the minutes? If not, those in favor of accepting the minutes, please say aye. Aye. Those opposed, no. Thank you very much. Motion passes. The minutes are then placed in the record. At this time, I'd recognize our legal counsel, Sarah Blakely, who will make a presentation of where we are here, and also she has a couple of ideas that may be of assistance to us. So, Sarah, you're recognized.
Thank you, Mr. Chairman. This one? No, that's,
No, you're right. Sorry.
yeah. I sent you all some correspondence that included question 1 through question 7-2. My correspondence is available, of course, on the website for the Charter Review Commission. I noted for every question whether there were some technical changes or corrections to scrivener's errors in each of those questions. I also drafted 2 questions that would combine some of the concepts and be able to reduce the number of questions that go on the ballot. So let me briefly go through those. Question 1 hasn't changed since the date it was approved. It was perfect then, it's perfect now. Question 2, I revised that to add the phrase "an affirmative" in the text of the resolution. No changes were made to this ballot title or the summary. This is one of those optional merger questions. Question 1-2 would combine questions 1 and question 2. Question 1 and 2 both deal with citizens' initiative petitions. Question 1 reduces the number of signatures required from 7% to 5%, and question 2 proposes to extend from 1 year to 5 years the time period which a Board of County Commissioners cannot repeal or modify the ordinance, except that during year 2 through 5, they could do it by 4 out of 5 affirmative votes of the Board of County Commissioners. Again, it's just something I drafted in case you want to reduce the number of questions.
While you're there, let me defer to Mr. Brinkman and Mr.
Thank
Little,
you.
since they introduced those, it matters, and see if they are interested in that or not.
Thank you. I appreciate that they are of similar subject, et cetera. My concern, frankly, is that when you combine 2 questions on a ballot, those who oppose either one of them are going to vote against both of them, and so it, to me, decreases the likelihood of either one of them passing when combined. So I personally would prefer they be separate.
I agree. Okay, as the sponsors of those, and unless somebody wishes to make a motion, that I'm certainly willing to defer to them. Okay? Thank you, Sarah. Thank you for the proposal, though. I know the Supervisor of Elections appreciates anything that you could do to make the ballot shorter, but we'll continue on.
Great. Question 3 is that dual vote city-county question. At the last meeting, you all adopted something that you wanted added, and I did add it into the resolution. In other words, the text of the charter amendment itself. It's a requirement that the proposing entity of a future charter amendment regarding certain municipal powers determine that the amendment fulfills an important county purpose. It also deletes the term municipal regulatory power and replaces it with certain municipal power, and corrects some scrivener errors. None of those changes actually affected the question nor the ballot title. They're just enclosed in the resolution.
All right.
And I believe the folks who were interested in this have had an opportunity to review it.
Is that Beth shaking her head there? Okay, we'll continue on.
Nodding. Okay, good. This is question 4, replacing the Board of County Commissioners with the Board of Charter Commissioners. This was the structural change that was made to the charter in order to get the charter out from under the provision in Article 8, Section 1E, which requires the legislature to determine a process for election. This allows for the setup of a variety of issues that could could happen, but in this particular instance, in your instance, the only issue here is the non-party affiliated election of Board of Charter Commissioners. So this is the structural change, question 4. The only change here is to delete in the very end here a reference to a question that you all rejected. I guess the nonpartisan is the one you rejected. You still have salaries on there.
I think we're right. Hold on. Do we have a name tag for Mr. Grummy? Oh, here they are. I'm sorry. Ms. Ferguson is in it. I'm sorry. I'm trying to get settled up here.
I understand.
Go right ahead.
Okay. Question 5 requires the Board of County Commissioners to set the salaries of the members of the Board of County Commissioners. The only change from last time to this time was a change in the number. Used to be number 6, now it's number 5 because you decided not to go forward with the non-party affiliated vote, the nonpartisan vote for charter commissioners. I did have a combination on this one, too, a merger, which would both replace the Board of County Commissioners with charter commissioners and require an ordinance to set their salary, all in one question.
And that way we would not have to have the one that says contingent upon
Correct.
number 4. Any members have a thought on that?
Well, go ahead, Mr. Martin. No, please.
Well, I was willing to defer to Ms. Redpath. I have a similar concern.
Okay.
Just in general of log rolling or dealing with two different subjects. Essentially, I understand one is, I guess, theoretically dependent on the other, but it's still two different subjects, and you're forcing, you're kind of divesting person from making a choice. In general, I'm against putting two different subject matters in one ballot question.
Okay. Mr. Brinkman, did you want to comment on that?
Well, I just wanted to be clear on something. There was language in there at one time where the salary could not be changed while the person was in office.
And y'all moved to delete that at the last.
Right, but I mean, that's not contingent on the charter provision, is it? I don't think it is, but I'm just,
Well,
in other words, without the charter provision, do you have to have that in? Or can you not do it at all without the charter?
That's actually a state.
right, it's a state law to have
Okay.
that in, and so if we're taking it out of the legislature's bailiwick and putting it to the local voters, then you can delete that, which is what the CRC did last meeting.
And that would not require a special act of the legislature?
Not under this theory of structural change that we have.
Okay.
Buddy, where's the agenda?
Here, have one.
Here's an extra one.
Here's an extra.
I think he's got it. Okay. Thank you very much. Have it all. Okay. I'm sorry, Mr. Martin.
Thank you, Mr. Chairman. Yeah, I, for somewhat similar reasons, I'm concerned about merging these two, especially in this case. I think that depending on how you read it, it kind of implies that the only reason we would be proposing this is for salaries, which I don't think is really the case. I think it's much broader than that, although this question, or this time around, the questions are fairly specific to this, like this issue. The change that, in fact, number, I guess, 4 would have is much broader than just the salaries. It changes it basically grants home rule more so to the people within Alachua County. So I think that this question combined kind of implies that this is the chief purpose, which I don't think is the reason. But I did have a question just of how this all works out, if I could ask our attorney.
Sure.
Obviously on the ballot, whatever goes forward is going to be the language that we have here, or whatever we end up voting on. Right. The backup to that language, where do people access that when the time comes? Would it be something, how do people access the empowering act, what the act?
The actual charter itself, the changes to the charter, because these are only the ballot title
Yes.
and the ballot summary.
This is what the voter's going to see when
Right.
they walk in the voting booth, but how will they see the actual backup language to these things?
Well, what we will do, the CRC, will be to give to the Board of County Commissioners, whose ministerial role it is to put these issues on the ballot. The form that will take for them is a resolution, much like I've set up each one of these questions as a single resolution each. And so we will combine all of those that you all have approved into a single resolution and present that to the Board of County Commissioners, and they will put it on the ballot. So it'll be a formal public record by the Board of County Commissioners.
I guess what I'm asking, though, is what the
Will it be a
voters,
handout or a-
what the voters will actually have access to. I mean, obviously, people who are really wanting to do research go to websites and whatnot, but is there going to be some type of public access to this?
I feel certain there will be. I can't answer the question because the Board of County Commissioners would have to do that and fund it and so forth, and they're very limited in what they can do anymore as far as elections or referendums. But I would hope that, similar to what's been done in the past, some sort of brochure or something be promulgated by the county, just as an informative type brochure, just strictly, here's the questions, here's the backup resolution, so you know exactly what's getting changed.
Okay, I was curious more than anything.
Yeah,
I
agree.
would just say, usually you could read all of the language in the newspaper prior to the election. That may not be in enough time because that comes out the week before the election.
Right.
But I would imagine it would be on the website, on the Supervisor of Elections website, that all the, when this goes through the county commission, all of the language will be there. I would imagine that would be the case.
We'll certainly
It's-
request that.
It's my understanding that the supervisor has to have it in by a certain date for printing, so I'd imagine if that's going to be for printing, it would also be on the website. I concur with him on that.
There's plenty of time for all that.
The actual wording of the resolution won't be on the ballot. What will be on the ballot is what was right here. It's my understanding also that there has to be at each polling place a copy of the actual language from the resolution. So I think that will happen as well. I know that's true for constitutional amendments, but then if you've got a lot of people who want to look at it, it might be.
Yeah, I would imagine, and we'll certainly be
Hope we will encourage.
working, yeah, we'll work with the county public information office to, and I'm certain they'll do some stuff. DJ Ferguson, do you want to, Ms. Ferguson, do you want to?
Yes, Mr. Chair. I just wanted to make sure that I clarify. So are we going to separate those questions again? Because I have the same questions that Commissioners Martin and Martin have.
Right now, nobody's indicated anyway,
Martin Square.
no one has indicated a motion or anything that they wanted to combine some. These were just proposals that Sarah
Okay.
put forward, but right now, we're right where we were when we left the other night. If nothing changes, that's where we'll be, other than her making some technical corrections just to clean it up a little bit.
We're a
Okay.
lot like the Pouncey twins.
I like having you on each side here. All right. Moving on. Let's go to number, Mr. Little, I'm sorry.
I'm sorry, I wanted to ask the question of when the county commission will have the resolution before it.
I think that's July 13th is what I'm seeing. And so we don't expect, we haven't worked with them on that, but it'll be forwarded to them, and however the manager and the commission want to bring it up, that'll be fine.
Information.
All right. Yes, sir.
I wanted to ask a question of Ms. Blakely again. I know that and I forgot, and I wanted to clarify it wanted you to clarify it for me. Because on one of them ones, I know that, and I'm sorry, I'm having a moment here that I forgot. For question 6, we used the word abolishing constitutional officers, correct? On question 6?
Yes.
Okay, and then on question, I guess it's 4, or whatever we're going to do with it now, replacing the Board of County Commissioners. What is the difference? And if you could explain to me so I understand it in plain language, not yes or no, but just explain it to me in such a way that, and for all the folks out there, what's the difference in abolishing constitutional officers and not abolishing and using the word replace, even though it sounds nicer, what have you? Why are we using the difference there?
Well, the reason is there is no practical difference. There is, however, a legal requirement that when you change the constitutional officers, you need to use the word abolish, because that is the term used in the Constitution, Article 8, Section 1D. And I believe that it's best practice to use that term actually in the question and obviously in the resolution as well. In contrast, Article 8, Section 1E relating to county commissioners doesn't talk about how you can change the structure of the Board of County Commissioners. So we're using the word replace in a way that's very similar to abolish, but because it's not constitutionally required for charter commissioners, we didn't use that term.
Thank you.
Okay, thank you very much. Please go right ahead.
Well, here we are on question 6 then. It's the one that abolishes the constitutional officers, replaces them with charter officers, and provides for them to be elected in a nonpartisan election. I deleted 3 words here to get them within the 75-word limit. As I said, my computer can't count, but I counted every word several times here. I would encourage you to, too, because no one's perfect. For this one, I, again, looked at that word abolish. Many of you had expressed some concern about that word, especially its prominence placement. So I drafted an alternative question 6-1, which is on the screen now, and changed the wording around some and actually hit on the head, I think, hit the nail on the head, what the purpose of this question is, and that is to provide nonpartisan elections of constitutional officers by abolishing them and replacing them with charter officers.
I'd just like to say that I like what you've done here much better because it does get abolishing right out of the beginning, and it also, the intent of what you're attempting to do, you've made it more clear by 6-1 because we are looking at nonpartisan elections. That's the objective. The rest of it falls into place, and then when you, by abolishing them and replacing them both together, it certainly makes a lot more sense to a voter, I think, if you were to go into the polling place and see this.
Just to clarify, why don't we, if you feel that way, why don't we put a motion that we substitute 6.1 to make it 6?
So
and that way
moved.
we'll have it clear.
Yeah, I'll make that motion.
Second.
All right, Mr. Wood, and it's been seconded that 6.1 become the actual wording on the.
Wait 1 second, though. The other thing I like is that you also, I think it was Ms. Baird last time that brought it before us that was saying a lot of the language that was utilized wasn't, the folks weren't understanding what we're putting in. This seems to clarify and make it clearer and how you worded this one versus what we saw last time, too. So I concur with my colleague.
As I recall, Ms. Baird was talking about question 3.
Yes.
It's still a little fuzzy.
Could I ask, you said that you changed 3 words in the following of this, or just in the front, in the beginning?
In question 6.
Just at the beginning of question 6? The statement?
Yeah, I just
Nothing has changed below the statement?
no.
Okay.
Thank you.
All right. Well, it's been moved and seconded. Any further comments on the motion, which is to adopt 6.1 as the actual wording for that question? Seeing none, any citizen wish to comment on that? If not, we'll just do a voice vote. Those in favor say aye.
Aye.
Opposed, no. Thank you very much. All right. Go right ahead.
That brings us to the subject of tonight's meeting, single-member districts for charter commissioners or county commissioners. I've drafted 2 different questions and resolutions. This question 7-1 would provide for the election of the county commissioners from electors in single-member districts. It does not utilize the charter commission concept, and as a consequence, it uses the exact statutory language that's mandated for when a change is proposed on the ballot. And those are the words that the statute uses, and that's why they're here. So we don't have any freedom if y'all want to adopt this. From a legal standpoint, these are the words that you need to use if you want to do the county commissioners in single-member districts. Question 7-2 is the alternative that will provide for charter commissioners from electors in single-member districts. It's contingent on question 4 being approved by the electors, which is the charter commission structural change concept. and then provides for the 5 members of the Charter Commissioners to be elected from single-member districts, with no more than 3 districts extending to the county line. That no more than 3 districts extending to the county line is not in 7-1 because the statute doesn't contemplate that. Instead, it is embodied in this question 7-2.
Thank you very much.
And, Mr. Chair?
Yes, sir.
On that note, I've raised the question previously about whether or not it is proper for the charter to specify how the districts are drawn, since I believe, is it the state law or the state constitution which gives the power to draw the districts to the county commission?
This doesn't change that. It's certainly,
7-2
section 7-1 does not change that.
I agree, but 7-2 does. It inserts that requirement. And I'm asking, is the requirement, is it the Constitution or the legislature which has given the power to the Board of County Commissioners to draw the districts?
The legislature.
Okay.
I mean, they've actually authorized them to go to single-member districts.
Right, but only using the language
Right.
set out.
It's in 7-1.
So,
That's
I
in
mean,
7-1.
to me, that clearly speaks to the fact that the legislature, only gave the power to go to single-member districts quite limitedly and did not contemplate having the shape of the districts or the manner the districts are drawn in set by anybody but the Board of County Commissioners. And so this is another instance where in my personal opinion, this should require a special act of the legislature as well as a charter amendment to make it effective. And I think that this method particularly is acceptable to challenge.
Okay. Appreciate those comments, and we'll have to see what motion gets made to see if that 7.2 even comes into play. All right. Well, we thank you very much, Sarah, for bringing us up to date and all the citizens up to date. We're going to turn to the reason that we're held this special meeting tonight, and that is to hear from our special guest tonight, Dr. Kenneth D. Wald. Dr. Wald is a distinguished professor of political science at the University of Florida. At the university, he has served as chair and graduate coordinator in the Department of Political Science, and he also has served as director for the Center for Jewish Studies. Dr. Wald received his BA from the University of Nebraska, where he was inducted into Phi Beta Kappa, and earned his graduate degrees at Washington University in St. Louis. He's the author of a number of books, and among his many appointments, he served as the consultant, I think more than once, I think several times, as far as single-member redistricting and districting for the city of Gainesville. So he is a recognized expert in this field. And Dr. Wald, we want to thank you for taking time to come be with us. I know that you made some changes to work on this, and we really appreciate you being with us and look forward to your remarks. And you're recognized to make any comments you wish to make at this time.
Okay. Thank you very much for the invitation, and I'm particularly grateful that you were willing to adapt to my travel schedule and adapt your work schedule accordingly. I should have put something in there about additional time to recover from jet lag, but we'll have to proceed as it was. Before I talk about everybody's favorite topic, which is single-member districts, I did want to say a few things. I want to just make sure you understand a few things about me in particular, which might influence what I say to you tonight. First of all, I want to stress that I am not an attorney, something that my mother was very perturbed about. But nonetheless, I want to stress that because of that, I would not purport to offer you definitive legal advice. You already have competent counsel to do that. There will be occasions when I will give judgments about aspects of the law based on my experience in redistricting and serving as an expert witness in 2 federal cases having to do with redistricting, but I do not do so as an attorney. Secondly, I want to make clear, contrary to what was perhaps hinted at in the Gainesville Sun a few weeks ago, there have been no conversations about my playing a formal role in this process if one of these amendments is adopted, no discussions at all, and no offers have been made, no discussion or thought about it. That might be a conversation for another time if it happens, but I want to make very clear that I was rather surprised to see my name in the Sun in that context. Finally, because there's a lot of discussion about people's self-interest here, and I'm mindful of the old saying in politics, where you stand depends upon where you sit, it's worth pointing out that I am a resident of the unincorporated part of Alachua County, not a resident of the city of Gainesville. What I would like to do tonight is to cover a series of basic questions about single-member districts. And those questions are put up here. What are they? Why have they been so widely adopted by local governments throughout the United States? What major issues do they raise? And these are the issues that you've been discussing. What are the standards that must be followed if you create single-member districts during the redistricting process? And what potential legal issues would be raised by the creation of single-member districts in Alachua County, apart from the issues that your attorney has already discussed? In particular, I'm thinking about some of the proposals that were submitted to you that I looked at, and some of the issues I think that would be raised if those particular proposals were to be the model for what happens. So, single-member districts, to put it very simply, are districts that occupy only a part of a governmental unit or entity. They elect one representative who must be either a resident or a property owner or otherwise qualified under state law to be a public official. And most importantly, the voting for that representative is restricted to adults who reside in that election district. That is contrasted with the current system we have in Alachua County, where every one of the 5 commissioners is elected in elections that are open to all adult residents of Alachua County. That is known as a series of at-large elections. We do have districts, but those districts are simply residence districts, which specify that the candidate for these various seats must be resident in the district. But under the law, residence districts essentially don't exist. They really don't count. So you're really talking about shifting from an at-large system to a system of single-member districts. Why have these been so widely adopted throughout the United States since the 1970s and 1980s? The reason for that is very clear. There is clear and compelling evidence that single-member districts significantly enhance the representation of ethnic and racial minority groups that satisfy several conditions. First of all, they are geographically concentrated. Secondly, they are politically cohesive. And thirdly, they have historically been the victims of discrimination and polarized voting, and thus often are described as protected classes under the law. In practice, the population groups that most often benefit by increased representation from single-member districts are African Americans, Hispanic Americans, and Asian Americans. Not all minority groups do benefit. The one in terms of political power that specifically does not would, of course, be women. Women do not tend to be geographically concentrated or politically cohesive, and therefore single-member districts do not in and of themselves increase their representation. We don't think they decrease it, but clearly that's not their function. Now, I should point out, single-member districts have never been required under the law as a condition of redistricting in the United States. However, when the Voting Rights Act was amended in 1982, Section 2, shall we say, established the conditions under which a person could lodge a claim demanding a switch to single-member districts. And that many localities decided that rather than test this in court, they would simply, in a sense, immunize themselves against such challenges by adopting single-member districts, even though they were not legally required to do so. The city of Gainesville, when it moved to single-member districts in 1987, was not at that time under a legal obligation to change what had been its system of at-large elections to single-member districts. There was discussion of a lawsuit. It was, I think, an open question as to whether or not such a lawsuit would have been successful if filed. But nonetheless, it's not a legal requirement. but it has become by far and away the most common form of representation in local government in the United States. And the most common type of single-member district is similar to the Gainesville city system, where you have a mixture of single-member districts and at-large districts, or what's called a hybrid system. But that's really the stimulus behind the adoption of this particular technique. I should point out that on occasion over the years, I have been approached by local governments that wanted to adopt single-member districts, not for the reasons connected with this law, but in some cases they wanted to fragment certain constituencies and actually diminish their influence in the electoral process. Being a free agent, not having to do consulting work to make a living, I was free to tell them I wasn't interested. All right. So what are the major issues that come up here? Before I go through these issues, which I've abstracted from your minutes and from the note that Chairman Irby sent me, I want to stress that some of these issues are issues where I can tell you things based on a preponderance of the evidence. In other cases, I want to be honest and say we really don't know with the level of precision that I would like as a social scientist to give you. I'll try to indicate where I think we're on very solid ground, and other cases where I have to be honest and say I really don't know, and you have to kind of decide on those issues themselves. One of the big issues that arises with single-member districts has to do with the accountability of the representatives who are elected to office. That is, do they think of themselves and act primarily as representatives of the county at large, or do they see themselves as principally the representatives of the district from which they are elected? You're familiar with the argument that a county-wide perspective is one that presumably is closer to representing what's considered the genuine interests of the county, and that it prevents people from voting on the basis of what are very sectional or perhaps very sectarian reasons that might advance a particular interest at a local level. And indeed, it's often been suggested that when you move from at-large to district elections, you get what some people call ward politics, where the members of the commission, particularly if you are entirely a single-member district, will only ask, is this good for my district, because those are the areas from which they get elected. Conversely, there are some people who advocate district elections on the grounds that it brings you representatives who are closer to the district, who have a deeper and better understanding of its needs, and a stronger commitment to serving as representatives of the particular area. In a sense, every citizen has a representative who they know is responsible to the voters of just that district. Again, one person sees this as good, another person sees it as a kind of ward politics. One of the real problems here is it's very difficult to think of a way that you could test this empirically, so I could say what the literature suggests. The reality is it is not easy to do, and nobody has come up with an approach that I think would be considered definitive. The only piece of literature I can cite for you at this point is the same piece of literature I cited back in the late 1980s when Joe Little and I were dealing with this, a book published, by the title of Your Friend at City Hall, a book written by Peggy Heilig and Bob Munt, which studied what happened in 5 or 6 American cities that made the transition from at-large to district elections. Several years after this had happened, the authors went back and interviewed people who'd been on the commissions both before and after the switch, as well as staff members, journalists, and others who were considered to be good informants. The fundamental conclusion of those subjective impressions was that it didn't seem to have made a whole lot of difference one way or the other. The people who thought that district representation would have dramatic effects were often somewhat underwhelmed by the consequences. Those who feared that moving to districts would undermine a broader perspective also didn't see much evidence that was happening. It's a very weak form of evidence. It's basically subjective impressions, not much more than anecdotes, but I'm afraid that's essentially the best that the literature has to offer. The second issue that's arisen has to do with campaign expenses. Would single-member districts reduce the cost of political campaigning? The logic here is if you only have to campaign in 1/5 of the county, reach perhaps 1/5 of the households, you can do that with cheaper media and less expensive kinds of approaches than if you have to operate on a county-wide basis. And therefore, the argument goes, people won't be spending as much money on ads and citywide publications, buying television spots or mass media spots, and otherwise will reduce the cost of political campaigns. Let me point out two observations here, one of which is this argument sometimes operates on the assumption that less spending on campaigns is better than more spending on campaigns. Curiously, the U.S. Supreme Court does not take that perspective. They would argue that political speech is a good thing, and if you have more political speech by virtue of more resources, that's not necessarily a bad thing. But more fundamentally, this is one of those assumptions, again, that while it has some logic to it, to my knowledge has not been tested empirically in a way that would enable me to say or quantify what the difference is likely to be. In theory, again, one would want to spend one's resources more efficiently, concentrate them, rather than do so through less efficient techniques like television and the like, which would reach a lot of people who are not, in fact, in the audience. But I'm not sure anybody's ever run the numbers, and I frankly can't give you much more than your own impressions based on this particular fact. Third question has to do with the effect on electoral participation. Some people think that district elections would stimulate voters to go to the polls because the candidates would be closer to them, would be more focused on the neighborhood, they'd be more likely to encounter the candidates in a way that presumably is not true with at-large elections. Here I'm inclined to think this will make almost no difference. If you were going from a pure at-large system to a district system, I would argue that single-member districts might very well reduce participation. What drives participation in local elections is, in effect, the mobilizing efforts of candidates. The more candidates running campaigns, the more likely you are to contact voters, to stimulate them, and thus to encourage them to turn out. And if you were going from at-large elections where everybody in the county could run for a seat, to a system where only residents of a district can run, you're probably going to have fewer people running and thus less mobilization going on. But the reality is you're not moving from a pure at-large system to this kind of district system. You already have a situation where the ability to run for that district is limited to residents of the district. So I frankly don't think there's likely to be any significant change in voter participation simply as a consequence of single-member districts. And I've looked for the literature for more recent studies, and I haven't frankly seen much, but I've also not talked to anybody who does work in this area who really thinks participation would be strongly affected by this kind of structural change. So I think it's essentially a wash. The final point is simply an observation on the fourth point about the effect on individual voter choice, and you can, of course, do the mathematics. Right now, under the current system of elections, every resident of Alachua County votes for all 5 commissioners, so everyone can say, I have a chance to vote for a commission majority. If you move to a pure single-member district system, every member of the county would be able to vote for one of the 5 commissioners, for obviously a net loss of 4. This issue was actually a fairly substantial issue that came up back in the 80s when Gainesville redistricted, and part of the reason a hybrid system was adopted is that it still allowed people to vote for a majority of the commission. You could vote for one of the 3 district commissioners plus the then 2 at-large commission, thus voting for 3 of the 5 commissioners. Now, of course, you can vote for 4 of the 7 commissioners, and you can vote for a city mayor. In Alachua County, of course, that's not a realistic option. As I understand it, nobody's talking about a hybrid district here. So you would be reducing the number of votes from 5 to 1. The consequence of that, again, nobody really knows because I'm not able to find any evidence that anybody's tested it. It might be that citizens might, in fact, feel less connected by virtue of having only one vote instead of 5. It might be that the tie that they develop with that one commissioner would be so strong that they would actually feel better about the county commission. Again, I don't think that there's much evidence one way or another on that particular issue. The final issue I want to discuss has to do with the representation of rural areas and minorities under single-member districts. And I actually want to defer that a bit because it gets to some of the legal issues that have to be discussed. So I want to talk about that issue that's probably been more important than any other when I get to the end of this discussion. So let's switch gears for a moment and talk about what has to be done in the act of redistricting a local government. Now, as you know, every local government should be redistricted every 10 years after the census is completed and there is what is considered the best data that we have available. So in that sense, nothing would change, and the existing ordinance within Alachua County provides for a redistricting every 10 years, as with the new ordinance. When it comes to drawing local government boundaries, you are under precisely the same standards as if you were redistricting a state legislature. The reason I gave you those two resources, the Levitt article or the Levitt booklet from the Brennan Center and the National Council of State Legislatures website, is because those standards are the standards that you have to follow. It is not as if you were redistricting congressional districts, which has a different set of requirements. You're in this case as if you were redistricting a state legislature. I've arranged the standards in a hierarchy of importance. Now, I must emphasize there's no explicit legal statement about which of these factors is more important than the other. But the body of case law that is built up under the Voting Rights Act and my experience as a federal expert witness has suggested to me that there really are, in a sense, 3 levels of seriousness here. One might even call them scrutiny, if one wants to use the legal term, that tend to arise in cases of redistricting. The first 2 issues that are, in my mind, the most important and that are the quickest way to catch the attention of a judge if there is a legal challenge, or for that matter, to generate a legal challenge, are the requirement of population equality and the requirement of minority representation. Under the principle of one person, one vote, the districts that are drawn for local governments should be as close as is possible to equal size in terms of the population. And I must stress, it is the total population one uses to draw districts, not the voting age population, not even the citizen population. Anybody who is resident, who is identified as a resident at the time of the census or thereafter, is the standard that one uses in drawing the districts. Now, the courts have come up with an informal norm because they recognize that sometimes you can't draw the districts in such a way as to get absolute mathematical equality. You start with the population, you divide it by the number of districts, and that's your target. That's what each district should be, but there's always going to be some deviation. The courts came up with, I think, a bizarrely measured way of assessing the deviation. If a district has more people in it than the target, that's a positive deviation. So let's say one of your districts is 5% too large, that is 5% over the target. And let's say you have another district that has too few people, it's below the target. You would then have a negative 4% deviation. You add together those 2 numbers, ignoring the signs, and you get the total planned deviation. In the case I just gave you, you add together the +5 for the district that's the largest district, which in this case is 5% larger than the target, and the smallest district, the -4, ignoring the signs, and you have a planned deviation of 9%. Somewhere in your past, you probably all were taught by a math teacher about the concept of absolute value, and you probably wondered, why on earth am I learning this? You were learning it for this moment, because it is the absolute value of the difference that we utilize, and I was so pleased when that first happened to realize I hadn't wasted my time. Yeah, now you've used it. Okay, now you've used it. We'll get on to algebra later. So generally speaking, what the courts have said is that if the planned deviation is within 10% or less, there's a very high probability that will be acceptable under the law. Sometimes it has to do with the nature of the district. Sometimes the courts will look at a plan that has a 3% planned deviation and say, that's too much. Sometimes they will accept planned deviations well over 10%. So it is a norm. It is not an absolute standard. But in redistricting, everybody who draws the lines will aim to have a planned deviation under 10%, because anything above it is going to heighten the attentiveness of the courts, and I think perhaps for a good reason, because it suggests a certain degree of unfairness. When we have a district that's too large, in effect what we're doing is diluting the votes of the people who live in it. If we have a district that's too small, we're giving their votes more weight. And so there's a reason why people are concerned about this, and that, to my mind, is one thing that you absolutely have to focus on, is trying to get equality of those districts. The second issue, going back to the question of minority representation, as we've said before, generally speaking, single-member districts enhances the representation of minorities which meet a certain set of criteria, as I've just discussed. And in the Voting Rights Act of 1982, it was emphasized that if you have a system which gives minorities a reasonable chance, minorities that meet the criteria of being geographically concentrated, politically cohesive, and so forth, and thus gives them a chance of electing representatives of their own choosing. And you then redistrict in a way which reduces that probability. You've engaged in what's called retrogression. And retrogression is a basis for a legal challenge to the system. So one of the things that people look at in redistricting is what effect this has on the ability of those minorities that have earned the status of being under strict scrutiny under the law. What effect does the change that you've made have on their ability to elect representatives of their own choosing? And again, I'm sure your counsel will talk more about this question. But again, I would say that population inequality and retrogression are typically the two issues which trigger a lot of judicial interest and a lot of judicial criticism when redistricting plans go into the court, which they may or may not. The next three criteria are the ones that I think have sort of medium significance. One requirement is what's called contiguity, which basically means you should be able to get from one part of the district to any other part of the district without leaving the district. And that the accessibility is the issue here. If you happen to draw a district which has a wide river running through it and that there are no bridges over that river, you're often thought to be in problem in terms of contiguity. If you have footbridges, it may be contiguous because a person could, in principle, go from one side or the other. But if you don't have vehicle bridges, that's more of a problem in some cases. So contiguity is normally something that violations of which are pretty easy to spot. But generally, the courts have been pretty forgiving, again, if it doesn't seem as a conscious effort was being made to deny somebody the franchise. If you have a little sector that's non-contiguous, there's a river that splits it from the district, and there's literally no way to get across that river other than boat, and if nobody lives in that little district, the courts will say that's okay. No doubt there would be a way to violate contiguity in Alachua County. I'm not quite sure what it would be, but in any event, it's one of those things that is usually fairly easy to identify. Not so with the next requirement, which is compactness. The courts have required districts to be as compact as is reasonably possible. The problem with this, as the Levitt document indicates, is that there are over 60 different ways to measure compactness, and not surprisingly, they can lead to very different conclusions about compactness. Essentially, and again, I'm taking the kind of liberty with court decisions that I know a lawyer would never take, and certainly not a law professor. I would say that what the court has basically said is avoid really bizarrely shaped districts. And many people have equated that with Justice Stewart's famous comments about pornography, that he couldn't define it, but he knew it when he saw it. In a sense, compactness is one of those things that you may not be able to define it with precision, but most people know a compact district when they see it and know what a district that isn't compact also looks like. There's some indication that compactness is coming in for more attention from the courts because they're a little concerned about the ability of the software packages we now use to district to achieve remarkable precision in tailoring districts in a particular way at the expense of compactness. And I think in local government elections, this is perhaps likely to get more attention than it gets even in state legislative or congressional elections. The final of the sort of middle categories is the idea that you should respect governmental boundaries. Now, this makes more sense in redistricting for a legislature. The idea here is that you should not divide unities or entities into multiple districts and fragment them. And we all know if that was truly something that the courts cared about, none of the Florida redistricting plans in the last 3 cycles for the legislature would ever have passed muster because they have done nothing but fragment all sorts of local government. So you can really get away with making those divisions. When it gets down to the county level, for local governments, I frankly don't know if this would really even be taken seriously by the courts. I suppose if you drew a line through a small municipality that in principle would not have to have that line there and had half the city in one district and half in the other, somebody might raise a question. But I'm fairly skeptical this in and of itself would invalidate a particular distinction. In redistricting Gainesville, I've taken this to heart in terms of trying not to divide election precincts from one another. I do that because our last 3 supervisors of election, starting with your commissioner and then going on through Bev Hill and Pam Carpenter, I think have drawn in their election precincts very good units to be the building blocks of districts. If you look at those precincts, you'll discover that they're actually crafted with an eye toward meeting both compactness and contiguity and making sure that there is a place for a polling booth that's in the center of the district. And so I've succeeded in all of the redistricting we've done in never crossing a precinct line. And to my mind, that's the most important thing to do. It does produce an administrative burden for the supervisor elections if you cross a precinct line with another line, because it means that different ballots have to be distributed to different voters, maybe even voters who are at the same polling station. So supervisors of elections don't like these. They can do it, but it just adds to the cost of elections because it actually has to be done manually in Alachua County. So it's not a trivial thing. That leaves 2 other criteria for districting which the courts have generally accorded a fairly low degree of priority to. Again, there are cases where these are important, but they're much less common than you might otherwise imagine. The first is the idea of representing communities of interest. The idea here is there may be voters who share certain histories, certain values, certain attitudes, and if they constitute natural communities, that can be represented without violating the other rules that govern redistricting, it's probably a good thing to take those into account. I must emphasize here that communities of interest are not the same thing as legally protected minorities. One might call college students a community of interest and imagine there was some interest in trying not to fragment their particular representation. They're not a protected minority. For one thing that makes a protected minority such is that the trait which defines the minority status is immutable. And while some of my students no doubt think that being a college student is a lifelong immutable trait, many of them eventually discover that they can move on. So we're talking here not about racial and ethnic groups in the way that we are when we talk about the Voting Rights Act. We're talking about other groups. And again, this is pretty much in the eye of the beholder. I'm not familiar with any case where the failure to take account of a community of interest led to the invalidation of a redistricting scheme. And I think it's something typically left to the discretion of the people who draw the districts. Finally, there's also the idea that it would be good not to interrupt relationships in the act of redistricting between elected representatives and their constituents, particularly if their representatives are legally eligible to run for re-election. One ideally, let's say, would not want to redraw the boundaries so that a sitting county commissioner in his or her first term, should you adopt a term limit, let's say, of 2, it would not be a good idea to, in effect, force that person out of the district or into the district with another commissioner, and thus interrupt the relationship that's been built between the representative and the constituents. Again, this is done. In fact, at the legislative level, it's become an art form to do precisely this, and many such proposals have been successful. But in all the redistricting that I did in the city of Gainesville, we tried very hard. We never put 2 sitting commissioners in the same district or, in effect, moved a commissioner out of a district that he or she represented. We did, on occasion, make changes in the districts that may have been more or less favorable to re-election prospects, but that, frankly, excuse me, was not a major consideration, and we never had complaints about that. And I think, in general, it's a good thing to do. Okay. Now, here's where I want to get to what I think are perhaps the more difficult issues that you're going to face in considering these various options that have been proposed and that have been suggested as ballot actions. It seems to me there are 3 big issues looming here if you decide to go ahead and recommend putting single-member districts on the ballot. Apart, I should emphasize, from the question whether you have that authority, which I know your council has dealt with and which I certainly wouldn't deal with. The first is, would the submitted proposals do a better job of representing people who live in rural areas than the existing system? Or are there any legal issues that might arise in this process? Secondly, would the proposals likely encourage retrogression and thus perhaps engender a lawsuit under the Voting Rights Act? And finally, would other kinds of legal issues arise here? Let's start with the question about the representation of rural areas. Now, I want to stress that in thinking about this issue, I've looked at the proposals that were submitted to you, most of which said they thought the best configuration you could get to ensure better representation of rural areas would be to limit the city of Gainesville to 3 commission districts and somehow divide the rest of Alachua County outside of Gainesville to 2. I don't know if the language you have discussed tonight about having a limit on the number of districts that go to the county boundary would do this or not, limiting it to 3. Frankly, I have other issues with that, which I'll be happy to share. But I simply wanted to ask the question, could you do this in a way that doesn't violate population equality, given the numbers that we're likely to have after the census is reported to us in the spring of 2011? I tried this 2 ways. The first way was to use the population estimates for 2008 developed by the Bureau of Economic and Business Research at the University of Florida. And I've got the link here to that file, which is at the UF website. I think I'm very impressed with the professionalism of the Bieber staff. They're often, in fact, contracted by the U.S. Census Bureau to do special studies. They're first-rate demographers, and I think their data is actually better than census data. But in any event, I used their estimates of what the population was as of 2008 in Alachua County, in the city of Gainesville, and in the remainder of the county. All right, we start here with the target figure for redistricting using these numbers. That you take, on the principle of one person, one vote, you start with the total county population and divide it by the number of districts. In the case of Bieber, their estimate is that as of 2008, there were roughly 252,000 people resident in Alachua County. You divide by the 5 districts, and your target figure for each district is 50478. I want to emphasize this is not voting age population, although I seemingly left out the word not. This is actually total population, which is what one uses in drawing the districting. So keep in mind the target figure here under the Bieber numbers is 50,500, more or less. Now, could you draw a 3-2 district, a 3-2 plan, 3 districts in Gainesville, 2 in the county, and still meet the requirements of plan deviation? Okay. All right. So, under this plan, if Gainesville were to have 3 districts, the average size of and you got them exactly equal, the average size of those districts would be 41,497. That comes from the Bieber estimate of the size of Gainesville, 124,491, or slightly less than half of Alachua County, divided by 3. And therefore, if you got it exactly right, each district would be 41,497. Now, I want to stress, if you're off by 1, the deviation is actually going to be greater than that. This is the lowest deviation you could possibly have given these numbers. I would use the mouse as a pointer, okay? Didn't realize I could do that. Oh, roll it around with this. Okay, I'll try that. Thank you. Okay. So, if you take, so the deviation could actually be larger than this. This is conservative. If you take, again, the 124,000, roughly 500 people estimated to be in Gainesville, and again, we'll know in 2011 how close this figure actually is, and you divide that by the target figure of 50,478, each of those districts would be 18% under the target. All right. The remainder of the county, based on the Bieber estimate, roughly 128,000 people, if it had 2 districts, would be 63,949. That deviation, which is a positive deviation because it's larger than it would need to be, would be 27%. If you add these 2 figures together and then ignore the signs, the planned deviation would be 45%. That is compared to the 10% norm. So if the Bieber estimates are close to the truth, and if you were to adopt a 3-2 plan that kept Gainesville, the city of Gainesville having 3 districts and everybody else getting 2, you would have a plan that would not come anywhere close to the 10% standard. And you'd have, frankly, people lining up to file lawsuits because, again, what you would be doing is devaluing the vote of people in the rural areas. It would take 64,000 of them to elect a representative and giving, in a sense, an advantage to the urban areas, requiring only 41,000 votes or citizens in a district there. And you would clearly be way off of the existing figures. Now, I thought I was going to leave it at there, but literally in this morning's paper, I read a press release from the Census Bureau that they have just released and just put up on their website their 2009 population estimates. It's for July 1 of 2009, and I thought, okay, let's see what their numbers show. I should point out they come up with smaller figures for both Alachua County and the city of Gainesville. I will tell you that if you ask me which set of figures I think is truer, I would tell you unquestionably I think Bieber's figures are more accurate. But under the law, it is the Census Bureau figures that matter. So at this point, let's assume that these have more force. And, of course, they're a year closer to the 2010 figures, which is what we'll be using in 2011. And, again, you can find their estimates here on a page. Okay. They say that Alachua County had 243,574 residents in 2009. Dividing that by 5 gives you a target of 48,715 people per district. That's a bit less than the 50,500 that you would have under the Bieber estimates. Again, using the same logic, they say that roughly 116,500 of those people live in Gainesville, and let's say we divide them into 3, and the remainder of Alachua County is 126,000, almost 127,000, and divided by 2, you'd have even larger deviations. The 39,000 average size of the Gainesville districts, if you got them perfect, taken as a percentage of 48,715, deviates by 20% under the target, whereas, again, the county figure would at this point be much larger, 30.3%, and the deviation actually goes up to 52.3%. So clearly, just using the proposals you have received that have said put the city of Gainesville into 3 districts and 2 for the rest of the county would not come even close to meeting the population standard. Now, I'm not suggesting that you would necessarily adopt precisely that language. When I looked through the proposals, there was frankly a lot of ambiguity about what people mean using terms like urban and rural. There are unincorporated parts of Alachua County, which I would argue, and I think the Census Bureau would argue, are probably urban. And people who were making the proposals were often not, well, I saw no references to the actual legal definition in this case. So I simply provide these as illustrations of what you have to think about with population equality in this particular concept. And I stress again, these are estimates because we don't have the data from the Census Bureau, and we can't go in and make much precise estimates about the districts until we get those small area numbers that come from the U.S. Census Bureau, the block data, which in Gainesville this time should correspond to the precinct data. So I'm using what I can, given the uncertainty about what we will find with the Census Bureau. That is why, in response to 7.2, which I just read for the first time today, I would have to tell you honestly at this stage of the game, if you said to me, can you draw a district map that meets the equality standard and has no more than 3 districts hitting the county boundary, I would tell you that I don't have a clue because we don't have the data, to put it very simply. But, you know, and that's, I mean, that would be an honest answer. I simply couldn't tell you if what you are considering putting in the commission charter is in fact possible. And if you do it nonetheless, and you develop a proposal that meets that requirement but violates the other standards, the plan could, I mean, it almost certainly would be challenged and most likely thrown out. So you have to always get your numbers to line up right. And I just chose the example because it's the one that emerged. Okay. Second point, what about retrogression? This is when you make a change in your districting that reduces the ability of protected minorities to elect representatives of their own choosing. Now, again here, because we don't have the data, I'm going to have to make some guesses and some estimates. And I will confess at the outset that I'm really unclear about how retrogression would be actualized in this particular set of circumstances. This is one of those cases where I really want to defer to your attorney here, because it's a complicated situation. And let me just, again, walk you through some of the thoughts that I've had. Again, let's suppose a proposal is adopted to try to limit Gainesville to 3 of the 5 single-member districts. That would mean that you would have to divide Gainesville, by definition, into 3 districts. Would that have the effect of making it harder for African Americans, who are the minority group of greatest interest because of their numerical concentration here, to elect a representative of their own choosing, as they presumably do under the current situation where you have residence districts? All I can tell you is that I think it would be exceptionally difficult, given the numbers that I expect we'll get from the census, to draw a district that had to be at least 1/3 of the population in Gainesville that would be not just a majority-minority district, which we have now for city elections. I think it would be difficult to draw a district that would be a minority influence or a minority access district, where you have a minority of the district being members of a protected minority who might, however, otherwise be able to elect a representative. In 2001, when I was redrawing the boundaries for Gainesville's 3 single-member districts, I told Marion Radson that I thought this was the last cycle at which it would be possible to create a minority access district in Gainesville. Not a majority-minority district, but simply a minority access district, given the population trends that were occurring. And I said to him, unless Gainesville goes to 4 single-member districts, which would be triggered by population change, or did something else, that there would be a serious retrogression problem in 2011 when the districts had to be drawn. As it happens, there were a series of annexations which pushed Gainesville's population over 110,000, triggering a procedure that called for an increase from 3 to 4 single-member districts and increasing the city commission overall from 5 to 7 commissioners. And we were thus able, in 2002, after the annexation, to restore District 1, which had been the minority access district, and make it an actual minority-majority district. I am dubious, given those patterns, that we could draw a district now that would be just in the city of Gainesville, produce a high probability of enabling the minority citizens to elect a representative of their own choosing. Does that constitute retrogression? And I want to stress, it's an assumption based on numbers and projections, so I could be surprised by the census data. I don't know whether the courts would think of this as retrogression, because the odd phenomenon here is you're moving from a system of at-large elections, which has produced fairly consistent minority representation, to a system of district elections that might make that less likely. On the other hand, the courts have said the issue is not so much who gets elected. The question is, do members of protected minorities, which may or may not apply in Alachua County, depending upon what the evidence would show about voting patterns and discrimination and so forth, would people in that category be able to elect representatives of their own choosing? Do they do it now when you consider the fact that even though there is a district that takes in a high proportion of African Americans on the county commission, the vote on that representative is, of course, county-wide? So I'm frankly not at all sure what the law would do with the claim of retrogression. I simply can't tell you. And here again, you have capable counsel, I think, who can look at that. There are just too many things here that complicate any kind of straightforward analysis. But it's certainly an issue that I think you need to take a close look at. And unfortunately, you won't really know the definitive answer until after you have the census data roughly a year from now, which is, by the time the state legislature will have done its damage and the precincts will be realigned in Gainesville, and then we can have a better sense. We won't really know whether this is the case or not until sometime quite late in 2011. So I'm simply raising a warning flag here that you ought to at least be aware of in your next step. Okay. I know you would like a clear answer, is this retrogression or not, and if the law was black and white in this context enough so I could give you one, I would. But the law here is very gray. If you've read the Levitt report that I gave you, you get some sense of just how much play there is in the law here. That's why I'm very concerned. Okay. Third question that I see, the third legal issue, and you'll be pleased to know this is the last issue, is this question of compactness versus communities of interest here. And again, I'm sort of going back to some of that discussion in the proposals you got about a 3-2 system, 3 districts in Gainesville, 2 in Alachua County. There's been a desire to create what proponents have called rural or outlying districts. Again, nobody's defined it with a great deal of precision here. That I think would have the effect of substantially, let's say, stretching the definition of compactness, whichever of the 60-some definitions one uses. Just kind of eyeballing some of the data that's out there, it struck me that more than likely, the only way you could create a district that would put together enough rural or outlying areas to meet the population standard, whatever that will be, would either be to create what I think of as a donut district, which would kind of run around the edge of the county, or a bookend district where you have Gainesville and it's kind of surrounded on either side, top or bottom, or side to side, by what you can think of as C-clamps with the C pointed inward. Both of those, in my mind, would raise real questions about compactness. In fact, a donut district is probably the least compact district that one can imagine. And I think it would activate, at least potentially, concern about a bizarrely shaped district. And here's the key. It may be a good thing in and of itself, but what you're effectively doing if you take that step is saying that a priority that is fairly low on the court's list, representing communities of interest that aren't protected classes, should, it seems, take priority over the things that the courts have said are really important: population equality, minority representation, and such. You can deviate from compactness if there's a very persuasive reason for doing it. And if you've ever looked at Florida Congressional District 8, you'll see a wonderful example of deviation from compactness. So it's not that you cannot draw districts which aren't compact. It's that you have to have a compelling reason to raise what is a priority of the 6th, 7th, or 8th magnitude to make it more important, perhaps, than the 1st, 2nd, or 3rd priorities. I would not like to have to try to make that argument, to be candid with you. So I think that you've got that particular problem. The courts would look and say, okay, you may have districts here that seem bizarrely shaped, that aren't compact, certainly could be more compact if you adopted a geometric perspective, in which, again, a wedge-shaped or pie-shaped districts probably make the most sense from that compactness perspective. Why did you draw a circle here instead? And I think to say because there are communities of interest that feel it's important that they be represented on the commission. Again, I think given the law, that's a challenge to make that argument. So I realize that I've thrown lots of data at you. I've tried to compress a lot. It's been 6 weeks since the semester ended, and I'm just overwhelmed with the desire to teach. So I apologize if you were my unwitting students in this process. But I will be happy to take any questions that you might have to ask.
Thank you, Professor. And believe me, your students are lucky indeed. We appreciate this presentation very much. I know. Did you wish? I know you early on. Okay. 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 All right. Mr. Martin, if you don't mind, Professor. Okay.
Yeah, thank you, Mr. Chairman. And I absolutely concur with the chair's remarks. As a political junkie kind of myself, I really enjoyed your presentation. And anyway, you spent a lot of time, and rightfully so, on the idea of districting that was of the 3-2 type of single-member districts where you create the donut or the county line issue. But it sounded to me, and I don't want to imply something that you didn't say, that the basic 5 single-member districts left up to be drawn by, I guess in this case, the county commission based on the legal criteria as you stated. You didn't, I don't think, I'm not sure if you made a case whether that was, it seemed like there were a lot of negative things about the 7.2 proposal, I guess, the alternate proposal, but on just the general 5 single-member districts, it didn't sound like that you had much issue with those. I don't want to read something in that you didn't say.
You're certainly right that 7.2 would concern me as a citizen, but also because, again, you'd be in effect telling the person exactly how to draw the districts without regard for the question about whether those districts meet the appropriate legal standards, and potentially demanding, particularly if it's in the county charter, that you draw districts that are almost certain to produce a lawsuit, and a lawsuit that I think would very likely win because the kind of gross disparities we've talked about. So certainly 7.2, because of the language about how many districts touch a county line, in the absence of data that tells us whether you can draw such districts in a manner that meets the Voting Rights Act and the court judgment is a matter of great concern. The question about whether or not the simple replacement of the at-large system with the districts is a good one or a bad one, I think depends on a whole range of issues, some of which I indicated we don't really have a lot of data to deal with here. One thing I think is interesting here, and again, your attorney might have more recent cases on this. Right now, peculiarly, I don't think the districts you draw under the current county charter, which are residence districts, are subject to anything like the legal standards that would in fact come into play if you actually make them single-member districts. Because I don't think the courts have said in qualifying people for office there is the same requirement of mathematical equality among districts that there is when the voters are factored in. Because right now, it's one person, one vote. Every seat is voted upon by every member of the county. So it's one person, one vote in a pure sense. I suspect, and again, I certainly would defer to Ms. Blakely on this, that once you move from residence districts, if you do, to the districts proposed in 7.1, you've suddenly acquired a whole new set of criteria that you have to think about, that you don't really have to think about right now. Because again, you one person, one vote comes into play. And that's the virtue of at-large elections. Nobody draws districts. There's really no challenge. And the residence districts, I simply don't. I think what the courts would say, if you want to run from a district, it's pretty easy. If you don't live there, you can purchase property there, open a business there, whatever. You can acquire whatever the requirements are to be a resident of that district. I'm astonished how easy Florida actually makes that. So for that reason, I think that a whole different set of criteria would likely come into play, and your county attorney would be much more involved in the redistricting than would be the case. There are other practical issues that I think might come up if you go to single-member districts. One of the things the City of Gainesville has always insisted on is they don't want city staff involved in the redistricting. They think it's a built-in conflict of interest if you have city staff drawing the districts of the people who are, in effect, their bosses. And so it's always been that they've wanted me to do it, and I mean, they will buy the data, but I have to have my own consultant and so forth. They want the staff to be really separated from this process. That's an issue that the county would have to deal with. Would they want the Growth Management Division, which has been handling this issue over the years, to get involved in this intensely political decision, which exists if you're actually drawing election districts, which you're not doing right now. You're drawing residence districts, and that has much less consequence in the process. So there are a range of things that could come with single-member districts that are different from what you have now. There are also this whole set of issues we talked about one's sense about if it's a good thing or a bad thing to have those districts. So I don't mean to suggest that the question in 7.1 isn't a question on which people can disagree. 7.2 is particularly a problem for me because, again, you're putting in the charter something that I think could lead you with enormous problems down the road. District 1 is essentially a policy and, to some extent, a philosophical argument. But it means that you will, in effect, leave the districting to the county commission without standards beyond those that are enunciated in the Voting Rights Act and have been argued by the courts.
Thank you very much, Professor. Further questions of Professor Little?
I would just like to ask for clarification and just to make sure that we understand it. Until now, I had never understood that anyone was proposing that the city of Gainesville was to be the site of 3 districts, that simply the center of the city of Gainesville was to be the site, and there would be no more than 3 that would include the city of Gainesville and the urban area. So I think the discussion about the great disparity is a little off the mark about at least what I thought had been considered, and you'd have to include within the center districts enough of the urbanized, unincorporated population to make your population requirements work, which I think could be done, at least from the point of view of numbers. And I wonder if that little modification of your analysis changes anything at all about your conclusions.
Well, as I said, I was drawing on the proposals that were submitted to you, many of which used the explicit language the city of Gainesville would have 3 and the remainder of the county would have 2, which made no distinction between, say, the county municipalities and the unincorporated areas, for example. So there was ambiguity in what was proposed there. And you're right, depending on how narrowly or how those terms are defined, many differences could occur. Using, I think, just the Bieber numbers, just doing some basic arithmetic, it suggested to me that if you put all of the city of Gainesville, again, into 3 districts, you'd still have to draw at least 40,000 voters from Alachua County in to meet the population requirements. That doesn't address the question of compactness or any of these other issues. So, yeah, my sense is that you simply can't do it the way that people have talked about doing it in that sense. Where this 3-2 idea came up with is not altogether clear. My concern, though, is you're putting constraints on drawing districts without having the data that tells you whether those districts are possible and whether they can be drawn in a way that would not generate a legal challenge. Every contract I've had with the city of Gainesville has had, both at the city's insistence and my own, language that in drawing the districts I'm also committing myself to defend them should there be a lawsuit. I would never want to draw a set of districts whose constitutionality and legality I had reason to consider. And I think whoever draws your districts has to have that same approach. And my concern is when you set the kind of constraints that you're talking about here, you're potentially putting somebody in that situation. And I say potential because we don't have the data. And we won't, the voters presumably will be voting on this, I gather, as soon as this November, and the census data won't be available for, another 4 to 6 months after that. So it's potentially legislating something that could get you into all sorts of trouble later on. Because, again, at the end of the day, this is about numbers, and one has to get specific.
Appreciate that, Professor. And Professor Little was correct that and you stated it also, that some of the proposals you looked at were the ones we'd received from our citizens.
Right.
And this commission itself had never really looked at anything other than some hybrid of city, county, making the numbers all about 50,000 if that should happen, which you've certainly enlightened us on. Any other questions, Professor? John?
I still have another question. Going back to basically some of your opening remarks that you made, there's been, the reason I'm asking this question, I'm going to preface it first. There's quite a few times we've heard people and people here and there kind of make the case that this is somehow the concept of single member districts, not one particular question or another, is a radical change. And I don't want to preference what you're saying, but it sounded, you made some comments that this is actually quite common and has actually been growing. It sounded like it's been growing in its use for the last 30, 40 years, because I think you cited since the 70s it's been a growing concept. So could you elaborate on that and also maybe reiterate why people have chosen to do this?
Well,
I don't want to misstate your...
Sure. Much of the early move to adopt this occurred in large cities. They might be counties, but they were almost entirely urban. And in most of those cases, it was widely believed that there was, in fact, a legal case to be made that existing representation didn't allow minorities who would otherwise be able to elect their own representatives from doing so. So in a lot of cases, this was made under the pressure or threat of legal action, and the assumption was, let's avoid all the expense of a lawsuit. And I can tell you one case. I was one of the witnesses in the Bradford County NAACP versus Bradford County Board of Commission when this case occurred. And the legal fees in that case alone, which was relatively simple, were well over $2 million. And that's quite a few years ago. I should point out I was a very small part of that $2 million in the process. So in many cases, when local areas were facing the possibility of potentially very expensive lawsuits, there was kind of a rush to move to the system. And initially it was pure single-member districts. Then the idea of hybrids began to catch on, and some people thought it maximizes the advantages of each system and minimizes the disadvantages by having the kind of balance, and that kind of became the fashion. Whether or not it's, and it was largely that consideration. When the city of Gainesville did this in '87, there were open discussions about a lawsuit. The NAACP in Gainesville had been discussing this, and there was clearly some awareness that this might happen. But I think fundamentally, and Mr. Little was on the City Charter Review Committee at that point, I don't think that was primarily what drove the Charter Review Committee. I just think they felt that it was, in general, a better way of running elections for an urbanized area. So that's really been the larger kind of pattern that's been there. We see it less in certainly rural areas where residence districts are much more common than is the case in the kind of urban areas. But again, you have some people, again, who believe that this gives every citizen a representative. Now, again, I think the most persuasive argument for single-member districts, let's suppose I'm a citizen and I'm aggravated by something that government has done or hasn't done. I know that's a very unique and seldom occurs, but let's assume I have that position.
Last night.
In a single-member district system, I know who my representative is in principle, I should point out. In practice, we know from surveys most people don't. But nonetheless, in principle, I can look it up and find out who my representative is. And if I go and scream politely at that person about the need to do something, that person has a very powerful incentive to try to address my concern, because ultimately I can determine whether he or she continues in office. If, however, I'm one voter in an at-large election, the incentive for any local government official to try to address my concern is accordingly less. So there's a belief by many people that having a representative in a single-member district really gives the individual voter somebody to identify with. Now, whether or not residence districts have the same effect is, I think, an open question, because it is the case that everybody in the county has a representative who is a resident of that general area, as you would under single-member districts. The difference is that individual does not depend exclusively on the votes of the people in the district to get reelected, but on the vote county-wide. And some people might argue, in point of fact, that therefore there is less incentive to be concerned with that need. Now, I was having a discussion with former Mayor Hanrahan about this whole issue, and her observation, and it's simply an observation based on her experiences in city government, is she thought there were at-large commissioner or at-large city commissioners who actually acted more like district representatives, and some district representatives who, to her mind, really acted more like at-large kinds of representatives. And this occurred by the kind of role orientation of the individual. It also happened because, frankly, most voters aren't aware of who those representatives really are. They have to look them up. So I think that it's hard, in principle, in theory, single-member districts should have that effect. I think in practice, it's not as simple as the theory would lead us to believe.
Just to clarify two things that you said, because I heard a lot of different aghast when you said about the $2 million. The Bradford County case, and I'm not asking about specifics, it wasn't the suit because they were single-member districts. It was a suit because they were not, right?
Correct. They were
So
at large.
The suit was to get them to go to single-member districts.
Right.
Correct.
Right.
The other thing I had, and just it sounded to me, and once again I don't want to put words in your mouth, that you made the point that the more urban in nature a political entity is, the more likely it is to move toward a single-member district. Is that a fair statement?
That seems to be what the evidence suggests, yeah.
Thank you.
Again, most of that evidence is earlier in time. There hasn't been as much of the work on this, really, since some of the Supreme Court decisions kind of made it a standard issue. But, yeah.
I really appreciate it.
Have you got time for a couple more questions, Professor?
Sure.
Okay. Mr. Grundy.
Oh, Mr. Brown.
Oh, Brunson for, okay.
Just wanna-
Martin.
Good evening. And
Evening.
I also did enjoy your presentation very much. I do want to ask you a specific question about the Bradford County, just to clarify. The move, as far as the issue that was, you outlined a number of issues that can come to garage from redistricting. The label of at-large or single-member district, but the legal issue that they were trying to address, it dealt with minority representation. Is that, and how it was impacted by the at-large or the single-member district, correct?
Yeah. Bradford County had at-large election districts. In fact, they only had one precinct in the entire county, which I found hard to understand. But it was an at-large system, and there, as far as I can recall, had never been an African-American elected to either the school board or the county commission. And there was a feeling that, given that the African-American community there met the conditions for being a protected minority, and with single-member districts, it was shown they would be able to elect representatives they're choosing. But they were forced into single-member districts, which is what has often been the mechanism, particularly for larger and more rural areas in dealing with this.
With the theory of retrogression,
Right.
That impact on minority communities is not tied to whether or not single-member district or at-large district, just some redistricting impact that causes a negative effect on minority access to the electorate, to public
Right.
office.
Right.
Okay, I just want to clarify that.
Mr. Wald. Thank you for coming this evening, and I did enjoy your presentation, and very insightful, and learned a lot too. I had a few questions of my own as well. You said a preponderance of the evidence that you received, or in some of the feedback that you just gave us, said that single-member districts, in and of itself, would benefit minorities, particularly protected classes of blacks, Latinos, and Asians, but not specifically women. Could you expound on that some more, and what preponderance of the evidence you were getting that from?
Yeah. This question has been researched in quite to a substantial degree starting in the 1970s, when this movement really for single-member districts developed. And what's clear is that single-member districts facilitate minority representation if that minority, again, is geographically concentrated, so there are enough members of the minority in an area so that they can largely determine the outcome of an election, if they are politically cohesive, if they vote together, and if they're in a situation where their cohesion runs up against cohesion in a different direction from the other population. So if you had a minority population that was scattered evenly throughout a county, let's say, and you could not concentrate it in a particular district, then single-member districting might not matter. And that's the situation of women. I mean, women are a large proportion of the population in the electorate, but they are not geographically concentrated, and they are not politically cohesive.
Okay.
So again, it's a mechanism that works if you can show that the circumstances justify it. And that's what the cases have largely hinged on.
Now, I'm going to follow up and I'm going to continue. And I'm going to do these in order, but specifically I'm going to stay within the realm of that question. A follow-up on that would be, you brought up the issue in 1987, the city of Gainesville went to single-member districts with, I believe, at that time, the first city commissioner that was elected under single-member districts would have been Commissioner Rodney Long, correct?
That's correct.
Okay. Between 1987, nearly over 20 years ago, to today, we can look at, I used the example last time of the election turnout specifically with geographic boundaries of single-member districts, predominantly for African Americans and Hispanics, predominantly in the east side. There has been many demographic changes in the city layout, housing layouts, housing patterns to wear that out. So what stood true in 1987 no longer stands true now. Also, the city looked quite different in 1987 than it did now, particularly with annexation. So would you still hold the same model of saying that you would have, I think I'll piggyback on this with particularly equality and the same benefits and protected classes with the amount of annexation and demographic changes, would it still stand true today?
I'll be able to answer that question definitively probably about a year from now. My guess is the city asked us probably about 6 months ago to look into the prospect of redistricting now ahead of the 2010 census because they were concerned about some population inequities. And the problem, of course, is that while we have estimates for the entire city or the entire county, we don't have really great estimates for small geographical areas like precincts or blocks or whatever. My consultant for that process was a man who is a former UF geographer and specialist in geographical information systems who now works for the U.S. Census Bureau. And we came up with small area estimates, but we frankly didn't have a lot of confidence in them because the error band, as we say, the imprecision is very large. So I'm giving you some judgment calls here because the data aren't particularly strong. My belief is despite the annexation, we can maintain in Gainesville a single-member district that will enable minorities to elect representatives of their own choosing. It may not be by as large a percentage as was the case in the past. But indeed, when we first created District 1, I think it was only about 43% African American, yet it reliably elected African American commissioners. So my guess is that we will be able to maintain that benefit within the city of Gainesville. Even though, as you say, there have been changes. The African American community is no longer as geographically concentrated as it was back when we did this. But I think fundamentally the numbers are probably going to support that.
I think what concerns me, and this is from somebody that's traveled to 88 different countries and many different cities, is that what stands true is not, and this isn't any different, and Gainesville is no different. Obviously, many of the citizens that come before us use Gainesville as a shining example, and I am a resident of the city of Gainesville. But specifically, they're saying that there wouldn't be any less representation for African Americans or Hispanics. There is no representation for Hispanics in any government entity for constitutional or what have you. But that said, too, particularly with respect to African Americans, within the city of Gainesville, you have seen a reduction because now you have a representative of one. It went from 2 to 1. So I think it marginalizes representation specifically for African Americans with respect to single-member districts, and we've seen that based on what has occurred in single-member districts. The only one that you have now representative has been, historically, you have Commissioner Sherwin Henry. You don't see anymore. Before that, you had Mr. Chestnut. Before that, you had Ed James. You can go back and so on and so forth historically. So I'm not seeing a benefit of increased representation. I've seen it marginalized, utilizing the example of the city of Gainesville.
I think this is one of those areas where we don't have the kind of evidence that can decisively resolve this question. Is it better for a minority community to have one representative? Does creating that system make it less likely that other minorities will then get elected? One of the arguments, ironically, conventionally given for single-member districts, and I didn't discuss this because this particular discussion has not primarily been about race in Alachua County in terms of creating these new districts. One of the arguments that's often made for single-member districts is it will enable an individual who perhaps could not initially be elected citywide, who might not be known to the voters in large enough number, to serve on the commission by being elected from, again, a district that's smaller where presumably people do know and are aware of what the person has done in a positive way. And that period of office, in a sense, brings this person to the attention of the entire electorate. So part of the argument is it kind of facilitates people who otherwise would not get elected in a large district to be able to do so. And I think there's some argument that may have happened in some cases here. So, I mean, I think there's lots of issues one would bring to bear, but fundamentally, I mean, that's not the issue you're dealing with here.
Correct.
I don't think anybody has argued the reason to adopt single-member districts in Alachua County as opposed to the current system is to promote minority representation.
Well, one of the reasons, the reason why I asked that, and granted it wasn't asked, but I asked it because it was asked by one of our colleagues on the board, and none of us failed to answer it miserably. But one of our colleagues asked, why are members of a particular section of our community do they feel that they will be misrepresented? I think that you actually illustrated this by some of your answers and some of the evidence that you gave to us. Another question I had for you was individual voter choice. You talked about that. You said there would be a net loss of 4 votes that one man for one vote, and make sure I'm notating that right. A net loss of 4, which has been my argument is why give up your right to vote for 5 to vote for 1? You're essentially not making the voting more inclusive. You're making it exclusive. So could you expound or opine on that as well?
Well, yeah, you're right mathematically. If you go to 5 single-member districts, the important point being single-member districts limit voting to people who live in the district. You as a citizen, all of us, as citizens of Alachua County, would go from being able to vote for all 5 commissioners to voting for 1. So the question is, what's the trade-off there? And some people, again, will argue that because that one district representative will be closer, will be more familiar with the issues, that it will give people, in a sense, a connection to the commission that they don't have now. The converse is precisely the argument that you made, that individual citizens will have less of an input on the broader commission than they do now, and will in some senses feel deprived. I was struck, again, back when we first did this in Gainesville, how important that issue was to so many people. I mean, none of us seems to be surprised that we only elect, one state legislator, from the district we live in, or we only elect one member of the U.S. Congress, and we have a relatively small share. But the idea at the local level was that was particularly a problem for some people. And again, that is, in fact, the reason why the hybrid pattern was so attractive to people in Gainesville. So again, I don't think there's evidence to argue either of those positions is correct based on the data, because we don't have data. They're essentially normative or philosophical positions.
And here's my last question for you. You also gave us some empirical data, and I looked at doing some of my own homework, is I've gone back to every election since 1990, both city and county. And city turnout for single-member districts, I went 3 years after single-member districts were enacted in the city of Gainesville. And looking at every election minus the 2008 election, which for obvious reasons was an anomaly. I won't say an anomaly, but there was a higher voter turnout. But specifically city turnout in elections for the city of Gainesville, since we continually use up here the example of the city of Gainesville, voter turnout has been abysmal in every election minus that. Yeah. And I guess the question, because there's lots of citizens that come up and say, well, it's going to be good for county government. This is why we need to do it. It's going to improve county government. And I think my question to you is, based on the numbers and the facts, numbers don't prove that it's going to be a more inclusive electorate or increase voter turnout in the county to go to single-member districts. If it hasn't done it for the city of Gainesville, why should we do it for the county? And I think that's,
Yeah.
next question.
I mean, yeah, I'll make a couple of quick observations. Turnout for City of Gainesville elections is always going to be proportionately lower than for the county because of the electoral calendar. Gainesville holds its elections in odd-numbered years that don't coincide with national elections. There's typically nothing else on the ballot, so the only mobilization that occurs is from candidates. When the county holds its elections based on the partisan calendar in even-numbered years, you get lots of people who go to the polls who end up voting in county elections, although I think it's fair to say probably many of them didn't go to the polls in order to do that. So, yeah, I mean, that turnout is always going to be low because of the nature of the electoral calendar. This has been discussed frequently in the city of Gainesville, and you're familiar with those debates. Some people actually think it's better to have those elections in off years because it removes what they see as the essentially irrelevant considerations of national elections from the election of local officials. Others say it's a scandal when only 20%, 15% of the voters go. And again, I think those are both normative arguments that you have to choose. I frankly don't think, again, based on what I've said, because you're not changing the number of candidates who are going to run. You're not changing the eligibility rules. If you were to go from the current system to single-member districts, you'd still have to be a resident of the district to be a candidate. It seems to me that's what drives turnout apart from the electoral calendar, and that won't change. So I would not expect turnout to change at all. And part of it's going to depend on the schedule. Do you have a year where there's only one district up, which we always try to avoid in Gainesville? Which tends to produce even lower turnout because typically the newspaper doesn't pay much attention when that happens. So, yeah, I frankly don't think turnout's going to be affected by this overall.
Thank you, Mr. Chair, and thank you, Dr. Wald, for coming tonight. One question I have, well, first of all, a little clarification. The proposals that we've considered actually would specify 3 districts going to the county line, from which it was my impression that the proponents actually intended to put Gainesville into 2 districts and the rest of the county into 3. That would actually make the numbers even worse, would it not?
Well, I haven't run them, but it was so substantially.
Yeah.
Yeah. It would certainly, it might reduce the numbers, but it wouldn't do it in a way that would save the plans now.
Right. Now, the other thing is on this eligibility of candidates. It's my understanding under the current residency districts, as you call it, that the qualification, i.e. the residence of a commissioner, is not judged by the supervisor of elections, but is judged by the Board of County Commissioners. And in fact, there is one sitting county commissioner right now who does not actually live in her district. And the problem with that is, I know someone who actually tried to challenge this, is the only person who can challenge it is a fellow county commissioner. Now, if we go to single-member districts, would that same situation obtain?
That's really a question for your attorney. I have no idea.
Okay, fair enough. What other, excepting Bradford County, which is obviously a fairly rural county, to my mind, to my knowledge, the districts in Florida, the counties in Florida which are using single-member districts are ones that are large, urbanized, and in fact have joint governments with the major city, such as Jacksonville and Miami. Do you know of any others besides Bradford County that are more like this county and that they have substantial rural areas?
To be honest, I'm not well versed on the specifics of which counties do use single-member districts and which don't, so I'm afraid I'm not helpful. Certainly the ones I'm familiar with are much more commonly large urbanized counties, or metropolitan counties in nature, but it's possible there are counties more like this that have it. I simply don't know.
Okay.
And just one other clarification. I believe you said that the city of Gainesville holds elections on odd-number years. Actually, they hold elections every year.
Every year, yeah, which means that they're often odd-numbered years when there's nothing else on the ballot, yeah.
All right. Well, we thank you.
May I ask one other question?
Professor Lount, sure. Yes.
Oh, sure.
One more? Okay. One more. Okay.
One of the, I suppose, a major reason that the single-member districts plan was offered was to provide what was considered better representation for people outside of the Gainesville urban area. And my question is, well, let me tell you the conclusion I've come to from what I've heard, and that is no plan that we've seen would actually do that. And what I'm asking is, if we had 5 single-member districts coming to a point in Gainesville, sort of like the 5 districts we have now for representation, can you see that there would be any advantage to the rural areas for having somebody elected from a rural area, simply on the basis of that change alone, nothing else?
I'm going to be on the fence here, Joe, because it seems to me that the answer to that question is essentially a philosophical question, and that is, how do you assess the quality of your representation? I was reading one of the submissions you had today that was sent to me by a citizen, and the citizen made the argument that he felt that he was not represented by the county commission based on the fact that he did not receive services commensurate with his tax burden. Okay. Now, I thought about that, and as one who lives outside the city of Gainesville, and I said, is that the appropriate way to assess the quality of your representation? And what, in fact, does it mean to receive services commensurate with your tax burden? I, for example, don't have any children who are in public schools, so one could argue that I actually pay more taxes for this purpose than I get direct feedback. Now, as I thought about it, I thought, now, wait a minute. I actually believe that investment in public schools is, in fact, a good for me. It makes a better community. For the same reason that I don't have to use the Alachua County Public Library very much, apart from the fact that my wife does it often enough, but I don't have to use it in order to believe it's a community benefit. So, in a sense, I may value certain things that one gets from the county commission differently from another person, even though we both happen to live in, Alachua County. So at the end of the day, the quality of representation is a judgment everybody makes for themselves on his or her own unique formula. And I wouldn't accept the formula, and I'd probably value the things at a different rate than this individual did. So that being said, I think it's very hard to say with any confidence that changing this electoral system would necessarily produce a greater increase in satisfaction with the output of the county commission. And we all know as well, politically, the law of unintended consequences is that you could simultaneously improve some people's satisfaction but diminish that of other people. So certainly this isn't a panacea. How much effect it's going to have, I think, is a judgment call. One of the things that sort of has struck me is there's been this assertion in many of the submissions you received that people who live in the outlying areas and in the county, in terms, again, that are normally not defined with explicitness, are generally unhappy with the county commission. I've heard that time and time again, feeling representation. And as an empirical social scientist who actually teaches and conducts survey research, I thought, well, there's an interesting research question. Let's do a good scientific survey of Alachua County. Let's see whether the level of awareness and satisfaction of the county government differs systematically by where people live. Let's see if we can attach a metric to this particular claim. Now, some people would argue that the Gainesville Sun does this through their clip-in or call-in poll. Those polls have no scientific validity whatsoever. My reaction as a social scientist is that I'm not, I'd like to see the numbers. I'd like to see the data on which it's based. Unless I have that kind of data, I would have trouble answering your question about what people would feel as a result of this particular change, one way or the other.
Mr. Chairman, may I follow up? Because I think I didn't pose my question wrong. I'm not speaking about how people feel about the decisions made by the county commission. Let's put it this way. Would the probability change that a person in overalls and a straw hat who never comes to Gainesville or near Gainesville would be elected in favor of or over a person wearing a suit who is from Gainesville as a result of going to single-member districts?
Someone who wears a straw hat, I'm conflicted by this particular question.
What I mean is somebody who
yeah.
has no connection with
Yeah.
with the urbanized part of Gainesville.
It would depend almost entirely on the nature of the districts. depending on exactly how you drew those lines. Because a lot of people who live in the county do in fact work in the city of Gainesville and have their livelihood directly connected to it, even if they reside in the county. So again, without seeing the exact shape of the districts, it would be hard for me to make that argument. Secondly, what enables some candidates to win and some candidates to lose are an array of factors. The funding they can raise, the organization they can put together, the social links they have through church, through organizations, their record of public service. So many factors operate. All of the things never are equal. That's the problem. It might happen if you drew districts a certain way. It might not happen. Dynamics here, again, social realities often trump electoral rules in this case. So I'm not sure it would happen. I'm not sure it wouldn't happen. I just can't be more definitive.
Professor, Ms. Martin had a quick.
I didn't have a question. I just wanted to have a comment.
If you'd like to make it, we're about to wrap it up here, so if you want to make it to the professor.
I think it was Mr. Brinkman who asked if there were other counties that had single-member districts. I believe Volusia County does, and Polk County. And both of those counties, I think, are very similar to Alachua County in terms of large urban centers and rural areas, too.
I know we were supplied some information early on with the different counties. No, appreciate your clarification there. I'm not seeing any more hands right now, and so
Wanted to make a quick comment that although I don't know if I've ever worn a straw hat, I certainly have, believe it or not, worn a suit at a time. I don't particularly care for them, but and I always see an example of an Alachuanian or whatever, Alachua man, who I don't think I've ever seen anything but a suit. So, but so
I appreciate
thought
that.
I would bring that up.
But I've anyway, appreciate. I don't know if you own any overalls, but they'd be big ones. I'll tell you that.
I once rode the tractor, which was only like a mile from where I was mowing up to vote in the city of Hawthorne, and that the reporters came around me and wanted to know. And of course, I was only like 18 at the time, so I told them, "Yeah, I drove this thing about 35 miles up here to vote." And they put me in the Gainesville Sun.
I think they made a movie about somebody who did that.
Professor, let me just say on behalf of all of us that often we say what a resource the University of Florida is, and it's a resource because of people like you. And I want to thank you for taking your time and coming down here tonight and answering our questions and sharing your knowledge with us. It means a lot to all of us and to our community, and we really, really appreciate that. And if you wouldn't mind, even though we don't usually applaud here, I'm going to applaud you. We thank you very much. Thank you very much for your time. With that, we'll move on with the agenda, which is we would open the floor if there is a motion, so we'll have something to talk about on the Mr. Grundy.
Make a motion to move forward. Question 7.1 to elect the single-member districts.
Is there a second?
I'm sorry. You go ahead.
Okay.
That's the one with just straight five single.
Straight statutory 5 districts. Straight statutory 5 districts.
Now, is it for sure that the Alachua County Commission would be the ones drawing the lines?
Yes.
That's correct.
Did I understand?
Yes, sir. Under the state law, and we'll let Sarah. Would you just talk? Since that'll be our motion, we have a proper second. Why don't you clarify that and so we'll know exactly what we're talking about? Okay.